Good day, ladies and gentlemen. This is Dr. Frel, your professor. Okay, class, good morning. We're back with our discussion on marriage. This morning, we will be discussing topic on the dissolution of marriage. So there are three ways by which marriage can be dissolved. One is by annulment. Second is by the declaration of the nullity of marriage. And third is divorce. So first, we have to define annulment. Annulment of marriage is a court proceedings which cancels marital relations between the husband and the wife. However, class, this annulment is applicable only to void marriages or those marriages which are valid from the beginning but can be declared void on various grounds. So this annulment class is the legal procedure for declaring that a marriage is null and void from its inception. It essentially establishes by civil law that the marriage never existed. So at if class, marriage have never existed from the beginning. However, if there are instances where a religious annulment was being given, it only nullifies a marriage for religious purposes only. However, the parties remain married under the civil law until the marriage is annulled by legal process. So we can say now, class, that an annulment is the other side of the marriage coin, in the sense that addresses situations in which one of the requirements for entering a valid marriage was not satisfied. Now, what are the consequences of annulment? So for children, in some countries, children born to marriages that are subsequently annulled are deemed legitimate under their law. They are typically described as children born out of wedlock. So, courts in annulment actions will usually make orders for the care, custody, and maintenance of the parties' minor children. In that case, class, children of annulment may need to establish legal parentage, to establish inheritance rights, or to file wrongful death for workmen's compensation claims for injury to a parent. So when the marriage of a minor child is annulled, the duty of his or her parents to pay child support is revived. So remember, class, that when a marriage of a minor child is annulled by legal process, no, the duty of his or her parents to pay their support is revived by that decision. So now let's talk about the difference between a void and a voidable marriage. Void marriage is a marriage that was never valid because it involves a union prohibited by law, such as when one party is already married to another person who is still living. While voidable marriage is a marriage that remains valid until it is rescinded in an action, typically by a party who has been wronged. So, if no action is taken to annul the marriage, then the marriage will remain valid. So again, class, please be reminded of the difference between these two marriages. Now, class, let's have the grounds for a judicial declaration of the nullity of marriage. One is the absence of essential or formal requisites of marriage. These are those that we have discussed in the previous video. Second are the grounds enumerated in Article 35 of the Family Code of the Philippines, or those that involve marriages that are void from the beginning. Third is psychological incapacity of the husband or the wife. Another is incestuous marriages. And last is those marriages contrary to law or public policy. Then under Article 45, these are the grounds of annulment of marriage. One is fraud. Second is the serious sexual transmitted disease incurred by each of the parties or one of the parties. Third is due to impotence. Fourth is lack of parental consent, that is if either party is at least 18 years old but below 21 years old and during the conduct of marriage. Then 5 is the consent for marriage obtained by force, intimidation, or undue influence. And last is the psychological incapacity or insanity of each or one of the parties. So now class, let's have the grounds for annulment of marriage related to legal capacity of the contracting parties to marry. We have one is non-age. This is when contracting parties are below the minimum age to marry and without parental consent or judicial approval. So again class, be reminded that the minimum age to marry is 18 years old. Second is by consanguinity. If these contracting parties are too closely related by blood under the law. This is what we call incestuous marriage. And another is by affinity, that is if contracting parties are too closely related by marriage under the law. Then we have bigamy or polygamy, that is if parties entering a subsequent marriage while a prior marriage of one or both parties is still in effect. Then we have now class the grounds for annulment of marriage related to the intent to marry. One of this is the lack of consent. So far there was no shared intent. If there was no shared intent at the time of the marriage to share the rights and duties of marriage due to mental incapacity or intoxication or other situations by which the intent to marry is not shared. Remember class that one of the prerequisites of marriage is that consent is freely given by the contracting parties. Then another class is duress, or that is if a threat of harm was made that compelled a party to enter a marriage contrary to his or her free will or judgment. Then the third one is undue influence, that is if a party entered a marriage contrary to his or her free will or judgment in response to another's improper use of power or trust. This is true especially class if children are, because of undue influence of the parents, they entered into a marriage contrary to their free will or judgment. Then another ground is impotency of a party, that is if it is not known prior to the marriage. The inability to have sexual intercourse is a ground for annulment. Although failure to consummate a marriage is not necessarily a ground. However, under the Philippine laws, then failure to consummate a marriage can be considered as a ground for annulment of marriage. Then another ground is of being an underage. So at the time of the marriage, a party was of an age when parental consent or judicial approval was required to enter a valid marriage. And lost is in case of fraud. That is, if a party made a false statement of a material fact that with an intent that the other party rely on the statement to his or her detriment by entering a marriage. So, the fraud here class must go to the essentials of marriage, such as having children or other reasons, no? And the courts generally must be able to find that the innocent party would not have entered the marriage were it not for the fraud. This is an example of this fraud class if in cases where a man marries a lady due to her pregnancy. However, the lady was pregnant with another man. Now class, let's proceed with the differences between annulment and divorce. So again class, annulment is when one or both parties claim the purported marriage does not exist, and the ground exists at the inception of the marriage. And annulment declares the marriage null and void from the outset or ab initio. And some rights previously terminated upon marriage may be revived. So again class, when we say annulment, the right of being single, no, on the part of the parties can be revived upon the termination of marriage, and there is usually no right to spousal support following an annulment. So once marriage is annulled, then support will no longer be required from each of the parties. While divorce, on the other hand class, is the termination of a marital union of husband and wife, but it recognizes that marriage between the parties still existed, though these are not allowed in the Philippines. But if the divorce is secured abroad by a non-Filipino and subsequently recognized under the Philippine laws. And of course, the Code of Muslim Personal Laws specifically recognizes Islamic divorce among the Muslims, of course. So this divorce severs a marriage the parties acknowledge exists. In the vast majority of cases, the cause for divorce arises after the marriage was established, unlike in the annulment where marriage is void from the beginning, and divorce terminates in marriage as of the date of the divorce judgment. Traditionally, after divorce, the parties have a continuing legal status as former spouses with respect to the custody, support of their children, as well as property division, and alimony and other benefits flowing from a prior marriage usually are not revived following divorce. So with divorce class, marital property is usually divided based on community property or equitable distribution principles. So they have to share it equally, class. Though in some countries, spousal support may be awarded based on one party's need and the other party's ability to pay. And the divorced spouses may now file a joint tax return for the year in which their divorce is granted, assuming they are married for some portion of that year. But class, under the Code of Muslim Personal Laws, they recognize Islamic divorce, which is to be granted only after all possible means of reconciliation have been exhausted between the spouses. So that's a plus. Now, how about foreign decree of divorce? The divorce decree granted by a foreign country must first be filed for recognition in the Philippine Regional Trial Courts. So once the local court recognizes the foreign divorce decree, it is registered in the local civil registry office of the place of jurisdiction of the regional trial court which granted the petition. And a copy of the registered court decree and certificate of finality to the local civil registrar office are provided to where the marriage was registered for annotation in the certificate of marriage. Now, how about legal separation class? So, legal separation is a court-ordered arrangement whereby a married couple lives apart, leading separate lives. So this means you and your spouse have decided that you no longer wish to live together in your marriage, but you are not yet ready to formally dissolve that marriage. So by that, you can separate from your spouse without court, but many people seek legal separation so they can have a formal custody and support plan in place during the time they are separated. So now, what are the grounds for legal separation? One is the repeated physical violence or grossly abusive conduct directed against the petitioner, a common child, or a child of the petitioner. Remember, class, the violence or the physical violence should be repeated, or it should be grossly abusive. Second is, there is physical violence or moral pressure to compel the petitioner to change religious or political affiliation. So, remember, class, compelling a petitioner to change religious or political affiliation is a ground for legal separation. Then third is the attempt of respondent to corrupt or to induce the petitioner, a common child, or a child of the petitioner to engage in prostitution or connivance in such corruption or inducement. Another is the final judgment that sentenced the respondent to imprisonment of more than 6 years, or even if later the respondent is being pardoned. Next is drug addiction or habitual alcoholism of the respondent. So class, alcoholism or habitual alcoholism or drug addiction of the respondent can be considered as a ground for legal separation. Added to that, class, is lesbianism or homosexuality of the respondent. And another is if contracting by the respondent of a subsequent bigamous marriage, whether it is within or outside the Philippines. So, bigamous marriage is also a ground for legal separation. Another is sexual infidelity or perversion of the respondent. Okay, you are very familiar with sexual infidelity and attempt on the life of the petitioner by the respondent, or the abandonment of petitioner by respondent without justifiable cause for more than 1 year. So again, class, abandonment for more than 1 year by the respondent without justifiable cause can be ground for legal separation. Now class, the last part of the video is on the rights and obligations of husband and wife. So under Article 68 of the Code, it is provided that the husband and the wife are obliged to live together, to observe mutual love, respect, and fidelity, and render mutual help and support. So they are obliged, class, to observe mutual love, respect, and fidelity, and of course to render mutual help and support. So husband and wives are obliged, no, to render help to each other as well as support. Next, class, the husband and wife shall fix the family domicile. In case of disagreement as to the family domicile, then the court shall decide. Then, the court may exempt one spouse from living with the other if the latter should live abroad or there are other valid and compelling reasons for the exemption. However, such exemption shall not apply if the same is not compatible with the solidarity of the family. Another obligation is that the spouses are jointly responsible for the support of the family, and the expenses for such support and other conjugal obligations shall be paid from the community property, and in the absence thereof, from the income or from the fruits of their separate properties. In case of insufficiency or absence of said income or fruits, such obligation shall be satisfied from their separate properties. Now let's talk about the management of the household. Under Article 71, it provides that the management of the household shall be the right and the duty of both spouses, and the expenses for such management shall be paid in accordance with the provisions of Article 70. That's the provision we discussed earlier. And then, when one of the spouses neglects his or her duties to the conjugal union or commits acts which tend to bring danger, dishonor, or injury to the other or to the family, the aggrieved party may apply to the court for relief. Okay, so class, it's very clear the provision of the law under Article 71 and Article 72. And last, Article 73 provides that either spouse may exercise any legitimate profession, occupation, business, or activity without the consent of the other. The latter may object only on valid, serious, and moral grounds. So again, class, each party is given the right to exercise any legitimate profession or occupation or business. Then in case where one party objects, this will only be on cases where there is valid, serious, and moral grounds. However, class, in case of disagreement, then the court shall decide whether or not the objection is proper and benefits has occurred to the family prior to the objection or thereafter. If the benefit accrued prior to the objection, the resulting obligation shall be enforced against the separate property of the spouse who has not obtained consent. Okay, so that would be all, class, for this topic. And for your activity, please submit a consolidated case digest on the following. 1. The Zara versus Guevara, say A40, first Socrates to number 236, and Bukat versus Mahas, and third is Guinness versus Bugayo. So Just submit your activity in the Google Classroom. Again, thank you for watching class. See you in the next video.